This is where we start. So the short answer is, do you need an estate plan? Yes. And what might happen if you don't have one? So to start out, an estate plan is necessary if you want to control and conserve your assets during your lifetime and after. The primary means of carrying this out is preparation of a trust, typically what's called an inter vivos or revocable living trust. Now, sometimes these documents will be prepared together. We can also talk, if we have time, which we should, about durable powers of attorney, advanced healthcare directives, and successor trustees. Now, I'm sure everyone here sometimes received a mailer from a law firm or another group promoting an estate planning seminar. And what they want you to do is come and hear a pitch that tells you how desperately you need to complete every document that they offer to you. And everyone's circumstances are different, and everyone's estate is different. It's not a one size fits all proposition by any means. Now, if an individual or a couple decide that they would like to have a revocable living trust, a will, powers of attorney for management of their financial affairs, advanced healthcare directives, nominations of conservatorship, certainly I can do all of that. But my role has always been to make sure my clients know what they need and are able to make informed choices. I don't ever want to sell people services that they neither need nor want. So, what might happen if you don't have an estate plan? I'm going to talk briefly about wills, but we'll go through those in more detail later. The person who creates a will is generally called the testator, as in last will and testament. And if your estate goes to probate with a will, it is a testate estate. If you do not have a will or a trust or any other plan, it is intestate. The intestate succession part of the probate code is detailed section 6400 through 6414. So without a will or a trust, you are intestate. You have no control over how your property might be distributed. In a particular case in point several years ago, a woman came to me, a client, recently married. This was not the first marriage for either her or her husband. He had no will and no trust, and he died unexpectedly. He did have 3 adult children from prior relationships. So an intestate probate proceeding was opened for her, by her, to deal with his estate. But the way these particular sections of the probate code worked out, his children from his prior relationships divided 2/3 of his estate, and his new widow got 1/3. And whether or not that is what he would have wanted, well, no one will ever know, but that was what happened because he didn't plan. Quite simple. So what is probate? How does it work? Why might you want to avoid it? Probate is the process for adjudicating an estate of a deceased person with or without a will. Now, if you are testate or intestate, you have a will or not, the process is pretty much the same. There's a certain set of forms that are filled out and submitted to the court. There are timelines to be met and things to be done. Creditors have to be notified. The estate assets need to be collected, preserved. The estate debts and expenses need to be paid. And ultimately, an accounting is filed with the court detailing what has been done, that it's been right, and asking that an order be issued allowing the final distribution and closure of the estate. The differences are that if you do not have a will, as I've already indicated, you don't have control and your estate might be distributed in ways that you do not want. The other is that you also have no control over who is your personal representative. It usually is whoever steps up first and submits a petition to the court saying, I'm the best person to do this. Now, when you go into probate, the initial petition is filed with a $465 filing fee. It's necessary to publish in a general circulation newspaper, which around here, of course, is the Press Democrat, a notice of the hearing. These days, that's $225. When the probate is officially approved to start by the court, it's referred to a probate referee. And when the estate assets are inventoried, it's submitted to him. He appraises them and charges a fee of 1/10 of 1% of the value of the estate. Now, one point to remember is if, for example, you have a piece of real property, a home, valued market value at $550,000 with a $312 mortgage outstanding on it, his value is market value. So with some other assets, if your estate is worth, say, $600,000, you're going to have a bill from the probate referee of approximately $600 to pay. It's one of the expenses that go with the estate. When everything is said and done, your final petition is filed with the court, it's approved, and that costs you another $465. So for a reasonably simple probate, you are going to pay fees and costs out of pocket, well, the estate will, of somewhere in the neighborhood of $1,200 to $1,300. More importantly, for a lot of people, there are two sections in the probate code, 10,800 and 10,810, which have identical sliding scales for the fees set by statute, by law, of what is paid your estate representative, executor, administrator, same function, different names, and the attorney who helps and represents them. It is 4% of the first $100,000 of value of the estate, so $4,000 off the top, 3% of the next $100,000, 2% of the next $800,000 of value, 1% of the next $9 million. So in a typically modest estate around Sonoma County, say $600,000, the fees paid each to the personal representative and to the attorney would total $15,000. Yeah, wow is right. It gets expensive. And that is a very important reason why you might want to avoid probate. There are some other issues. Court backups, necessary timelines. Within my practice, the fastest time I have ever completed a probate was approximately 9 months. If you have real property to be sold, depending on the condition of the property, what has to be done to clean it up and make it marketable, what the market is, the cooperation or lack of cooperation by the estate beneficiaries, it could take 2 or 3 years. And who wants to wait that long? It's in everybody's interest to get it done, but that just does not always happen. So that's probate. Now, what avoids probate? Life insurance is not part of probate so long as the beneficiary is still alive. If you have a husband and wife, for example, and the husband has a policy that pays out to his wife who dies first, and he does not have a secondary beneficiary, that becomes part of his probate estate. So if he's got a $100,000 policy, that raises the value of the estate by $100,000. Very simply there, if you have insurance policies, make sure that your beneficiaries are current and lined up. Investment and retirement accounts, such as pre-tax funded IRAs, are not part of probate and should not be. Joint tenancy property bypasses probate. And you probably know that in California, that's the common way for a married couple to hold real estate. If you have a bank account and you put one of your adult children on as a joint tenant with it, when you die, it passes to them automatically. It bypasses probate. That's fine. However, if you have your child on your house as a joint tenant, there are two issues. One being, if you want to sell the house, they have to agree. The other is that when you die, they take title to the house. It bypasses probate. If they want to sell it later, they have a low tax basis for the first half they received when you created the joint tenancy, and they pay potentially a much higher capital gain tax on half of the proceeds of the sale. Not to anyone's advantage. Now, if you have a small estate, $166,250, that's sort of an odd number, but a year ago, the state legislature increased it from $150,000. That's considered a small estate. There's an expedited process outlined in the probate code. 40 days after the death of the decedent, you can prepare an affidavit, a copy of the will, if there is one, and a copy of the death certificate, if there's a bank account, if there is other property, present it to whoever is holding the property, and it should be released to you without having to go through probate. And for most people, bypassing probate means putting your property in a trust. If you want a will, it's a fairly simple process. I've done quite a number. Very seldom are they longer than about 5 pages. It includes a statement identifying yourself, that you establish a will and revoke any prior wills if you have them. It details who your heirs at law are, that is your spouse, your children, your grandchildren. expresses the intention to distribute your property, who it is going to go to, in what shares, who it will be distributed to, and importantly, who is not, who is omitted. I have not personally encountered it, but there are cases and circumstances where a child or a grandchild was specifically left out of a will. When it went to probate, they stepped up and said, well, wait a minute, I was grandma's favorite grandson and she left me out. It had to be a mistake. Well, it wasn't a mistake, but rather than fight it, they end up getting a share of grandma's estate when they weren't supposed to. So typically, if you are going to leave out for a reason, perhaps a child who has a substance abuse problem or has borrowed a great deal of money and not paid it back, and you feel that they've had enough, it has to be very expressly included. Your will can include specific gifts of property, jewelry, or family heirlooms to particular family members, and gifts to charitable organizations, your church, your alma mater, Rotary Club. Your will nominates who your first and second, ideally second choice for your executor will be, and provides that they should be able to administer your estate without having to file a bond, and that they can do it under the Independent Administration of Estates Act. Previously, anytime the executor, the estate administrator, wanted to take action, they had to return to the court and get specific permission. The Independent Administration of Estates Act allows them to file and serve a notice that they're going to do something, sell the decedent's car, sell the decedent's property. As long as it's served on all the beneficiaries and no one objects, they can proceed and take care of business in an expeditious manner. When your will is prepared, very simply, it is witnessed by two people. They must observe your signature, and they cannot be someone who is going to receive part of your estate through the inheritance set out in the will. And that's done. A trust is an instrument that allows ownership, management, and distribution of your property during and after your lifetime. For this discussion, we're talking about what is generally called an inter vivos or irrevocable living trust. So technically, a trust is a legal entity. It is a three-part process. You sit down with the drafter, typically an attorney, create the document detailing what your property is, how you want it handled, how it will be distributed at the end, who your successor trustees will be. It is signed, and although I have not yet found, and I've looked, in the probate code for a requirement that it be notarized, I personally believe that it is a good idea, and I always have my clients notarize their signatures to their trusts. And it needs to be funded. So being a legal entity, your trust can own property, your home, rental property if you have it, your business, can operate a business, it can rent your rental property, hold your bank account. Most of my clients primarily put their home into their trust. It is their largest asset. You should not put an IRA, a pre-tax funded account into a trust, the IRS considers that an early distribution and will take a very large tax bite out of it when you do, once they learn. But other parts of your stock portfolio, CDs, checking and savings accounts, all go in the trust for your management. It means you have to create a new checking account with yourself as the trustee to manage the trust and write the checks. But from that perspective, you as the trustee continue to own and manage your property. You can pay your mortgage. You can pay your utility bills. You can do anything as the trustee through the trust that a real person can do with their property. Now, typically, those who create the trust, the term I generally use is trustor. They're also in different documents called a grantor or a settlor. So if you come across that, again, they all mean the same thing. Typically, they are the trustee or trustees, husband and wife, very often. I've done a number of trusts for individuals rather than couples. But the advantages of a trust are several. In addition to holding your property and managing it during your lifetime, a trust can extend beyond your life. It can hold money or other property for children or grandchildren to provide for their education, their general welfare. It can hold property for the benefit of surviving spouse for later distribution to children or to a charitable organization. This is a function that's frequently used by couples who come into it from prior marriages. And this can all be done under the directions of your successor trustee. Now, who is your successor trustee? Well, if a husband and wife form a trust, they are trustees together. One of them passes away and the other will continue in the role of trustee managing the property. They can enlist an adult child to serve as a co-trustee with them, and most often it is an adult child who is nominated to serve as successor trustee to manage the trust and wind up affairs when all is said and done. It may be a sibling. Now, that can be difficult. Pardon me. I know that parent-child relationships can be rocky, or your adult children may live on the other side of the country. It may be difficult for them to do that. It may be that your siblings are older than you, and chances are they will not be able to help you as a successor trustee. One option is to have an institution or a professional sit in as your successor trustee. Now, once upon a time, most banks had a trust department. My research into it indicates that not as many do. For example, Redwood Credit Union does not. Exchange Bank does. But a few months ago, I talked to them on behalf of a client, and the response was that the minimal annual fee that they charged would be an unnecessary burden on that particular estate, and suggested that I find an individual instead, which I actually thought was a good testament to Exchange Bank as being community oriented. Now, I'm a member of the Redwood Empire Estate Planning Council. It's a group of professionals, attorneys, accountants, fiduciaries, bank trust officers who are involved in estate planning work. And through that, I've become acquainted with and can connect with several professional fiduciaries that work in Sonoma County. They're spread all the way from Cloverdale to Petaluma, Sonoma. As I recall, there's one with an office in Novato. I've talked with several, and they charge for their time on an hourly basis at a reasonable rate. And if you are in a position where you do not feel that you will have someone you can depend on to help you manage your trust, if by some chance you are unable to do it, or to wind affairs up for you when you're no longer there, these people are bonded, they're professional, and they would, in my opinion, do a good job. Now, one instance I encountered that was a little problematic, I had one client who didn't know what to do about this. She didn't want her children burdened with it, and she wanted me to be her successor trustee, which according to the rules of the state bar, I couldn't do. I would not, but there's the implicit assumption that because I had drafted her trust for her, I was taking advantage of her somehow. And we went around and around about that many times and finally worked it out, and she found someone else to do it. But basically, if you have an attorney prepare your trust or your will, they are not going to be able to serve as the person who helps settle things out in the end. Now, why is a trust better than a will? A will, as I said, is fairly simple. It's a straightforward document. You prepare it unless circumstances change and you need to put someone in, a new grandchild, take someone out. Um, it sits there in your safe deposit box, in my lockbox in my office, in a file in your drawer, and it just waits until you die. If a will costs, say, $200 to prepare, that's fairly inexpensive. But as we talked about earlier, the end result when you go through probate can be thousands of dollars. And if you're lucky and things go smoothly, it will take a year for your estate to be processed and closed, and perhaps not. A trust is more expensive, but it is a substantially more complex document, and it is effective immediately, including transfer of real property into your trust, which requires preparation of a grant deed and recording fees. If a trust costs $1,200 to $1,500, this is hypothetical, well, it's a lot more than a will. On the other hand, when the trustors are gone, the successor trustee contacts the attorney. There's a notice required by the probate code that goes to the beneficiaries and potential heirs, informing them that circumstances have changed, and with the death of the trustors, the trust has become irrevocable. That's served on everyone. They have 120 days if they want to ask questions, review the trust, make any objections. If they do not, the door closes and everything can be wound up privately and quietly and in an efficient manner. The other reason you would prefer a trust, most documents filed with the court are public documents. When you open a probate, you lodge the original copy of the will and you prepare a photocopy and attach it to the petition. Anyone who sees the notice that's published in the paper that John Derby has passed away and his estate is going to be probated can go down to the courthouse. Well, I'm not sure these days with COVID, but normally could go to the courthouse. You fill a slip out, a request slip, and hand it to the clerk, and they'll pull the file, and you can sit there in the court clerk's office and read through and see what John did with all his money and who's going to get it. You know, I don't know how many people do that, although in the course of representing clients through probate, I do get frequently advertising for letters from all kinds of companies that want to provide services, selling property, buying property, any number of things. So there are those who look at the ads. Trusts, as I said, on the other hand, are private. Now, there are other trust formats that we could talk about. I'm going to move on to talk about durable powers of attorney and advanced healthcare directives. But very briefly, if you have a child or grandchild of diminished capacity, depending on public benefits, you can prepare a special needs trust, which is designed and intended to supplement their life, but does not replace the benefits they rely on. If it did, they would have to spend through whatever they received and then go through the process of requalifying for SSI or public housing Section 8 benefits or whatever they had. There are various uses for irrevocable trusts, something for which you need to be very specific because it is what it says, it is irrevocable. Grantor retained interest trusts, charitable remainder trusts, qualified domestic trusts, which I will mention very briefly. If you are married or a partner of someone who is not a U.S. citizen, and they are your co-trustee, your co-beneficiary in the trust, if you pass away before they do, they cannot be the sole trustee. They have to have someone who is a United States citizen to serve as a trustee, a co-trustee with them to administer the trust. The point of this is that the government is afraid they're going to withdraw property and spirit it away out of the country without paying tax on it. And it is something that I've encountered a couple of times and needs to be paid attention to. So what is a durable power of attorney? Do I need one? And why? Generally, a power of attorney is a document by which you, the principal, give the power to manage certain property or all your property and make decisions to another person called your attorney in fact or your agent. A power of attorney can be as broad or as narrow and specific as you want it to be. Basic power of attorney, as a matter of law, is revoked, it's canceled, if you become incapacitated through age or illness and can't make decisions for yourself. If you have a situation where you have property that is not in your trust, that your successor trustee in that capacity, in that job, could not manage or control for you, you probably want a durable power of attorney. Now, it is the same as a more garden variety power of attorney. However, it contains the specific language that if you, in the opinion of your physician, are unable to make decisions, are incapacitated, it survives that point and becomes effective. So the person you have designated as your agent can step in and manage your property for you. Now, any power of attorney, whether durable or not, as long as you are able to make decisions competently, can be revoked or amended at your choice. Now, there are several things that your agent cannot do for you or to you, if you will, under a durable power of attorney. They cannot make a will, a codicil, which is an amendment to your will, for you, or revoke your will. They can't make a living will, which is another term for an advanced healthcare directive, to suspend artificial life support. They can't exercise any ownership over a life insurance policy owned by you that insures their life. They can't exercise any power under an irrevocable trust that you have created and which you were the trustee of. And generally speaking, they cannot make gifts to themselves of your property unless you have specified that they can. Advanced healthcare directives, also known as durable power of attorney for healthcare or a living will. So an advanced healthcare directive is a healthcare related equivalent of a durable power of attorney. Now, legally, these are separate things. If you prepare a durable power of attorney for business and financial affairs, it cannot also be a durable power of attorney for healthcare. But an advanced healthcare directive, living will, however you wish to describe it, gives you the right to decide several things, put those decisions down in writing, and nominate someone to carry those decisions out for you. Do I want to be resuscitated if my heart stops and I'm not breathing? Do I want sustained life support if I fall into a coma, a condition that is frequently called a persistent vegetative state? Do I want pain medication if I am in pain, even though it might hasten my death? Do I want to allow or deny an autopsy? Do I want my body donated for medical research? your agent under your durable power of attorney for healthcare will have the right to examine your medical records, to speak to your medical providers, to make decisions for you when you can no longer do that, including carrying out your decision that you do or do not want to be resuscitated or be put on sustained life support. As with a general power of attorney, anytime that you want to change it or revoke it, as long as you are competent to make those decisions, you can do so. None of the documents we have talked about today are written in stone. Any of these, your wills, your trusts, your powers of attorney, your advanced healthcare directives, can be modified if your circumstances change. If you change your mind, it can be revoked. Returning to trusts on this subject, you form a trust, you fund it, your real property or your bank account. As life goes on, you can add property to it. You can take property out of it. You can change the terms of how much your beneficiaries get, add beneficiaries, or delete them. You can do the same with a will. An amendment to a will is called a codicil, and it, like a will, is fairly simple to prepare, short and to the point. Everything I've talked about today should be notarized except a will or a codicil to a will. One point, returning again to advanced healthcare directives, if you are a Kaiser member, they have a form. You don't need to hire me or any other attorney or go online and pull up a form. Kaiser has one. And I've helped people go through them, and it's very complete. It has space for you to add additional directions if you want to do that. And at this point, I've covered what was on my agenda, and I'd like to leave some time for questions.
Okay, let's see how we should do this. Remember, if you want to ask a question, to unmute yourself and raise your hand ahead of time, and I guess I'll call on you, and then Jim can answer the question. How's that? Who's got a question? Okay, Chuck.
Thank you, John. So we had our trust and our will done by an attorney friend of ours about 10 years ago. Have there been any changes in the law since that point that would, by which we would be encouraged to make changes? That's question one. I'll hold question two for a second.
Okay. Well, depending on what your intent was with your estate, the only change that has come up recently, and it's now sadly too late to address it, was that the people who promoted Proposition 19 kind of pulled a fast one on us. Up to February 16th, transfers of property, real property between parents and children, were exempt from reassessment. Now they're not. And there was a fair amount of scurrying around to make adjustments for people who had created trusts, leaving their home to their child or their children, and dealing with that issue before February 16th. But other than that, there are no substantive changes in the last couple of years that I think would be necessary to be concerned about.
Thanks, James. The second question is this. If we determine that upon our passing, we wanted to leave X number of dollars to the church, would that best be done by a codicil or a change in our trust?
Well, let me, I have two answers to that. First of all, it depends on where the money is held. As I said, some people, basically they put a clause in the property schedule at the end of their trust that they leave everything, their household possessions, their vehicles, their garden tools. They put that into their trust. Other people put in their house and maybe a bank account. If you have the account, which that money would come from, in your trust, then it is simple enough to have the trust amended if necessary to leave that to the church. If it is not in the trust, then the same thing could be done with your will. And what some people do is create what is called a pour over will. It names their trust as the primary beneficiary of the estate, so that avoiding the probate process, if there might be sufficient assets over 166,000 to require probate, it is figuratively poured into the trust and distributed under the distribution directions set out in the trust.
Question?
Yes.
Who?
Sam.
Oh, okay, Judy. Oh,
I still don't quite get the difference between what you would put in a will and what you would put in a trust. Is a trust mostly the money part of it, and a will is who gets my aunt's china? Or what?
Well, your trust, either document would have both. People put the money part into the trust because they don't want it to go through probate. They want to avoid the time and the greater expense of the final administration. But your trust, once you transfer your home or your stock portfolio or your savings account into the trust, then you have to have some account of how it is going to be distributed in the end.
Sam, did you have a question?
Yes, I wanted to make sure I understood that if you have a living trust, but you also have some things outside the trust, if it's no more than 150,000 of value outside the trust, it won't have to go to probate. Is that what I understood?
That's correct, Bill. It's 166,250 these days, but that is correct. And that excludes real property and certain other items, but basically financial accounts, heirlooms like jewelry and antiques that might have substantial value. There's an expedited process that they can be transferred to whomever they are supposed to go to without having to go through probate. I did transfer one piece of real estate through a separate part of the probate code that follows the same process, but it can't be valued at more than $50,000. And I don't think there is a piece of dirt in Sonoma County that this was a kind of godforsaken rock out in Riverside County.
Virginia, you have a question.
Well, I put this in the chat, but I wonder if you want to
Oh.
make a change to your trust, you know, the value your disbursements, like if you want to add somebody or you want to change a name, it's the same person, but their name has changed because of marriage. Do you need to go through an attorney to do that, or it would be just writing it in there and having it notarized? Okay.
Well, I won't say you necessarily need to go through an attorney, but you don't want to just write on the original document. What you need to do is basically, in a nutshell, you identify that you know we Virginia Greenwald established this trust. Section 3.2 says that she has the power to amend it. Then you say, I am changing this section. It now reads whatever the change is. You sign it and have your signature notarized.
Okay,
That should be legally effective.
so just a letter or a notice in there stating
Yes.
wow, I want it changed. Okay, thank you.
Hannah just had her shot today and wasn't sure what sort of condition she'd be in. And you look
I'm
sort of
not
bundled
bad.
up. You're
I'm not bad, but I am reclining.
You may feel it tonight, though. Anyway,
Yeah,
I
I
don't want
may.
to paint a bad picture. Go ahead with your question.
Yeah, well, while I'm still on this side of the ground, I have a sister who lives in France. She is an American citizen. She has a trust. She is married to a French person. She has a daughter who lives in Switzerland who is also a dual citizen. I believe that her trust states that her daughter would then, administer it after she's gone. But would I be wise to get myself added as a second person if, for God forbid, any reason my niece could not fulfill the function, because she's the only other American citizen who has access to the trust?
Was the trust drafted in California?
Yes.
I think that would be a prudent idea.
Okay, because I can't remember, and I will check to see, but it occurs to me, as you say, the difficulties with more than one nationality. Okay, thank you.
Yes.
I have a question. Oh, Judy, go ahead. You unmute yourself, though.
Yeah.
Yeah.
The difference between a revocable and an irrevocable trust. I've been told that to protect myself from indigence, if my husband had to go into a nursing home and it was going to eat up all of our funds, that I would need an irrevocable trust instead of the revocable trust that we have now. Is there a nutshell answer to that?
Probably not. Probably not. I know that with the typical revocable living trust, you are the trustors, you serve as the trustees, and you're the primary beneficiaries. And where I think you would need to be going there is to create an irrevocable trust in which someone other than you was the trustee. That leaves you out as a middleman, but it's not there really isn't a simple answer to it, no.
There was somebody before this seminar had wondered where you could find someone to administer your trust that was trustworthy.
Yeah.
And I think you answered that pretty well. You said that that you are a member of the association, and there are people that are out there that do this that are presumably responsible. I hope we have answered that that question, and I saw a nodding head. So good job, Jim.
And I'm going to take a moment and put my contact, do some self-promotion and put my contact information up on the slide. Just for anyone who is actually interested. But I think I can still hear, and if there are further questions, I'd be happy to answer them.
Well, thank you very much, Jim. Is there anyone that would like to have a last word or a last question? I'd like to thank Jim very much for yeah, this is the way we clap in church, so it doesn't make any noise. We're very grateful to you, and I think you did a good job, and you finished on time.
You covered an enormous amount of territory for us.
Yeah,
So
you really did. Yeah.
really appreciate
I thank you for inviting me, John, and I was really happy to be here, and hope that what I said helped some people figure out what they need to do or might want to do, or that they've already done the right thing.
Okay. Well, if your Zoom screen is like mine, the end button is down on the lower right-hand corner. And
Thank you, John, for putting this together.
well, you're welcome. So good, have,
And see you at
aloha.
church.
Thank you.
Okay.
Thank you.
Bye-bye.
Bye.